My name is Marck Joseph, and I'm a South Florida family law attorney. And you're here to learn 5 things you should know about child support in the state of Florida. Child support is the obligation of both parents to care for a child or children that was born between them, whether they were married or not. The child support process can be initiated in a multitude of ways. When 2 parties or one of the parties file for divorce and there's children involved, child support must be established. Another way is if one of the parents is receiving government aid as it relates to the minor child or children. The state of Florida will, on its own, establish the child support. A third way that child support can be initiated in the state of Florida is if either party files an establishment paternity action against the father. I have a previous video that discusses this topic. As a convenience, we've included it in the description below. If you've noticed, when I described what child support is, I said it was the obligation of both parties to support the child or children that is common between them. This means that both the mother and the father can both file for child support. Let's say, for example, there's a situation in which the father's rights has been established because, let's say, they were married at the time. If the father is taking care of the children are staying with the father and does not spend time with the mother, it is the mother's obligation to then provide child support for the father. There's other ways in which the mother can be responsible for child support to the father, or the father could be responsible for support to the mother. Under the state of Florida, from the date child support is sought, they can go back up to 24 months from when the child became of need and request what is called retroactive support. This is different from a child support arrearage, which is when you are behind on child support that's been already established. How long does child support last? Typically, child support lasts until the child turns 18. However, if the child turns 18 while they are in their senior year of high school, it can last until the child graduates high school or the child becomes 19, whichever occurs first. How is child support calculated? Okay, I'm going to ask you guys to bear with me on this one. Child support is calculated using a chart, which is established in the Florida statute. This is a very complicated chart. However, we included a link to the PDF below of an example of this chart. But in summary, the way it's calculated, it's using the net income of both parties. And based on that net income determines how much child support would be for 1, 2, 3, or multiple children. From there, depending on how much time both parents have with the kid or children, determines how child support is. What also can get included into child support is if either party is paying health insurance, any daycare aftercare expenses for the child as well. So if you want to take a shot at it, you can. Just download the PDF before. But this would be a perfect example of when you should really consult an attorney. A family law attorney specifically could help you get an idea of where your child support obligation could fall based on the facts of your case. Now, I would like to disclaim, there is a lot of other factors and considerations that need to be taken into account when child support is being dealt with the courts, in terms of whether how you want it established and how you should go about it. I strongly suggest that you consult with an attorney to address these issues, as not doing so can negatively affect your case or circumstance. So if you or someone you know has any questions or issues with child support, contact my office and we'll set you up for a consultation. And if you enjoyed this video, like it, subscribe it, and take a look at some of my other videos. Thank you for watching.